Commissioner Didier here in the courthouse.
Morning again, Clint. All right, looks like we do have a live screen. And it is 9 a.m. and all three commissioners are in the courthouse in their offices, or I'm sorry, two of us, I think possibly Commissioner Peck is remote. And we have Keith in the office and Amanda is at the computer this morning. So with that, we will call this meeting to order, and we will start with the Pledge of Allegiance, please.
I pledge allegiance
to
to
the
flag
To the
of the
flag
United States of America
United States of America,
and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Our first item on our agenda this morning is approval of former minutes for July 28th, August 4, and August 11. There's no addition, changes, or corrections. I'll sign them as presented.
Mr. Chairman,
Yes.
on those minutes, on the July 28th, we had a call in by a Juan Morales, is what's stated. And after going back and listening to the tapes, on the August 11th, it's listed as a Juan Morales, but it's the same person, it sounds to me. I think we're getting things confused there and adding additional names. I think we need clarification on that.
Okay. So it's the 28th of July and August 11th.
Yes. And on the August 11th, when he called in, there was a severe amount of background noise.
Correct.
Could not hear what he had to say. And I would ask that Keith would please let him pause until that background noise would dissipate it, because I couldn't understand hardly what he was saying.
Yeah. All right. Well, Amanda, will you note that? And we'll look at those minutes.
Also, on the July 28th, on the very back of the minutes is prosecuting attorney Sean Sand made the comment and rebutted the statement that I made about the U.S. District Court, where the governor didn't have the authority to enforce his proclamation, but Sean states in there that the prosecutor and law enforcement have that authority. But later in his statement, he says that, is Sean on the phone? He isn't?
No, he's on vacation.
Oh.
Jen Johnson's on the phone on behalf of the PA's office.
Later, he states that he does not agree with the governor orders. And so if he doesn't agree with the governor orders, does that mean he will enforce it? And if not, we already know the sheriff will not enforce it. Also, the courts are having court cases with the defendants in the courtroom with the attorney. They're wearing masks. And I'm just asking why we're not in the chamber under those same conditions.
Mr. Chairman,
We're
well outside the scope of the meeting minutes discussion. If Mr. Didier wants to bring this up as a separate topic later, that's fine. But we're talking about minutes now. Let's move on.
It's in the minutes. This is in the minutes.
No, Mr. Didier, you're well outside the scope. Either there's a correction to the minutes that you want made, or there's not. We're not going to rehash and debate the issues.
Excuse me, you're another commissioner. The chairman is the one that rules on this.
And that's who I was speaking to. Mr. Chairman, point of order, please move us on.
Yes. Yeah. Discussion about the minutes can be a correction, but not a discussion with the attorneys. So,
okay, we'll save it for later in the meeting.
Okay. So what I am understanding is the fact that August 4 minutes are signable July 28 and August 11 needs, some adjustments.
Clarification on the name and also that if our administrator would please pause until all the background noise would be eliminated.
That's understood. Thank you. Okay. We'll move on. It is stated in the agenda as public comment, but as I said in the past, the phones are open at any time. Don't hesitate, and we'll do our best to accommodate them as fast as we can. So don't hesitate to call in at any time during the meeting. With that, anything, Keith, on the phone?
I don't have anything on the phone, Mr. Chairman, but I did receive a written comment that the author has asked to read into the record today as a public comment.
All right, please.
Commissioners, thank you for the service and for the service of everyone involved in this meeting. I also applaud your continuation of public comment at meetings, something the Pasco City Council has suspended. I write in opposition to the use of Pacific Office Automation's scanners in any area of Franklin County official or citizen business. This is a massive invasion of privacy on its face to require medical information of anyone to enter a public building as citizen or employee is unlawful according to HIPAA and unconstitutional on Fourth Amendment grounds at least. It is a clear slippery slope starting with county employees and ending on citizens. As reported by the Tri-City Herald, Benton County is using these machines, but in order to set our minds at ease, they made sure to mention that the facial recognition and badging/marking features of these machines would not be implemented, that only temperature checks would be used. It is naive to think the extra features will not be used in the near future and that other features won't added features like contract tracing or vaccine compliance. The camel's nose is already under the tent in Benton County. Don't let anywhere near Franklin County. This is all being done in the misguided notion of stopping a virus that has a death rate of less than 1% based on inflated numbers, and the inflation methods are documented. To put this in perspective, based on the health department's own numbers in Franklin County, more unborn babies' lives will be ended by abortion than lives will be ended by COVID. No one is considering placing restrictions on Planned Parenthood of Pasco, yet we are considering spending thousands and invading the privacy of thousands. Commissioners, I call on you to resist these machines or anything like them. Sincerely, Justin Carey from Pasco. That's the only comment we have at the moment. Commissioner, in some reference to the background noise that Commissioner Didier mentioned, I appreciate the helpful guidance there. I will say also that we've noticed this morning that the city of Pasco appears to be removing a tree in Volunteer Park across the street and is using a wood chipper. So any background machinery noise that you hear in today's meeting, we will do our best to avoid, but we may pick up some of that on our microphone.
All right, thank you. Nothing on the phone?
No, sir.
All right, we will carry on to Kyle, please, for discussion on criminal justice treatment account.
Good morning, all. I came today to discuss the criminal justice treatment account and additional dollars that were allocated for this fiscal year. At the August Greater Columbia Behavioral Health meeting, which took place August 6th, there was a discussion amongst the 8 member counties regarding these dollars. So for a little bit of background, currently there are treatment service dollars that are allocated to Franklin County. All of those dollars go through Greater Columbia Behavioral Health. They're contracted out to Merit Counseling Services, and they provide treatment and drug court participation and whatnot. There were new dollars allocated for either the creation or the expansion of therapeutic drug courts, therapeutic courts, and so an issue came up at Greater Columbia's meeting. In their bylaws, they have the ability to contract solely with service providers. Counties, most of the counties within Greater Columbia are not service providers. These dollars are specifically are slated for either counties or cities, again, for the creation or expansion of therapeutic courts. So we had a discussion about this, and it was advised or determined all the counties were going to go back and have a discussion about these dollars with their BOCCs. So after the meeting, I got out and I pulled the RCW and read the RCW, and it states in RCW that there is a panel. Each county is required to have a panel that creates a report, if you will, or a template, a guidance for the Board of County Commissioners to sign off on how those dollars are spent. And so the panel was very specific, and it includes the County Drug and Alcohol Coordinator, which quite frankly doesn't exist anymore. In 2016, prior to 2016, the counties oversaw the substance abuse contracts, and there was a drug and alcohol coordinator that oversaw those contracts. That position went away, but included in the panel is a county prosecutor, county sheriff, or their designee, somebody from the Superior Court, substance abuse treatment provider appointed by the county legislative authority, a member of criminal defense bar appointed by the county legislative authority, and then a representative from the drug court. And so there's again, it's their task to develop a plan that is brought before you guys to sign off on with a recommendation on how that funding is spent. And so, like I said, again, I think initially the hope, I think, at Greater Columbia was that we'd come back at the next meeting and have recommendations moving forward from each of the counties. I don't think we're even at that point. I think in how I'm viewing this, and I'll preface this by saying that I have an email sent to Tony Walton, who is in charge of he's with the Healthcare Authority. He's in charge of the CJTA program. And so at the ASO, at Greater Columbia, they talked about this panel guiding these new dollars. And I'm certainly no lawyer, but how I read the RCW is I believe that we probably always should have had a panel, and that panel should guide all of the CJTA dollars. And so the reason I came before you today is to ask to be able to move forward with the creation of this panel. I would, if the board directs me to do so, I would have obviously I'd have to work with the representatives that are required by statute to participate in the panel. But at a later date, I would have a resolution that would come before you guys, essentially creating the panel and identifying who needs to be a part of that. And just so you have a dollars and cents kind of understanding, for Franklin County, the current or the previous funding, the continual funding, I guess, if you will, for services is $7,577 a month. The new dollars are $6,591. And again, it's for fiscal year. Obviously, there's no guarantee that it's going to be renewed next year. But again, I think these are some dollars that could go to help citizens and that need these kinds of services in Franklin County. And so I certainly don't want to just ignore the dollars either. But I do have some questions that unfortunately I don't have answers for you guys, because I need to get those questions answered from the Healthcare Authority first. And I haven't gotten a response to my email yet.
Mr. Chairman, this is Commissioner Peck, a couple of questions.
Yes, please.
Kyle, the 6,591 a month you just mentioned, is that in addition to the 7577 a month that's ongoing, or is it
It
a
is.
replacement amount?
It's in addition.
Okay, so we're looking at about 140,000 a year, and those dollars are specific to Franklin County, as I understand. The participants in this panel will be unpaid volunteers and county employees as specified by the RCW.
Yes.
Okay, thank you.
And Kyle, this is, Greater Columbia has been handling these dollars previous to this, haven't they?
Yeah, the issue that came up is the service dollars, the $7,577, $7,577. They contract those to Merit. I can't remember if it's Merit Counseling or Merit Resources, and they provide services for drug court participants that don't have other methods of pay. The new dollars are specific to drug courts and or therapeutic courts, and are earmarked for either cities or counties, again, for either the creation of therapeutic courts or the expansion. The issue that Greater Columbia is having is they don't have, in their bylaws, it states that they'll only contract with service providers. And the counties, most of the counties, quite frankly, in Greater Columbia, if not all of them, none of them are service providers. So that's what sparked this initial discussion. On top of that, these dollars are earmarked for something specifically different than the other dollars, although those dollars can be used for drug courts also.
So the $2 we're speaking of can be married together, as Commissioner Peck was talking about, to roughly $140K a year.
Yes.
Yeah, probably even more than that. My math is off a little.
Yeah.
Yeah. Now, I don't know if now Commissioner Didier wasn't a commissioner at the time, so he may not be aware of this, but a few years ago, when the state was was trying to kind of dot all their I's and cross all their T's, moving towards full integration of mental health, SUD, and physical health, there was a letter sent out to the board identifying whether or not the board, whether the county wanted to take back control of the CJTA dollars. Now, obviously, this was referring to the $7,577. Take back control of those dollars, or to allow greater, or the ASO, it was sent out to all the counties in the state, or allow the ASO to continue to manage those funds. And at the time, the board decided to keep things the way they were, and to have Greater Columbia continue to administer the funds. All of the counties that participate with Greater Columbia, except for Walla Walla, chose that path. Walla Walla County chose to manage the funds themselves, and so I think that's, maybe as part of the panel's discussion, that's also something that needs to be addressed. Is for the $7,577, does the panel recommend to the board that Greater Columbia continue to oversee those funds, or if the county would like to take control of management of those funds? Again, I think that's a question ironed out maybe a little bit later in the process.
So Kyle's Commissioner Peck, just want to correct, the number is about 170,000 roughly all in. Could you give us an example, or maybe two, of how the dollars would specifically actually be spent? Who would be paid and for what? Just to give some clarity to how these dollars are to be used in a therapeutic drug court setting.
Yeah, and so there will be, they can use them to pay for, drug court participants are required to receive UAs. These funds can pay for that. If there is an individual that is a participant of drug court and they don't have Medicaid, they don't have private insurance, part of the requirement is that they receive treatment. These dollars can go to pay for that treatment. I think that the existing dollars, the new, they can pay for case management services that would be provided to the clients that are enrolled in drug court. There's a number of eligible services with the existing dollars, and again, the new dollars can't supplant existing funding. It's to either enhance it or to create something new.
And these dollars come from the state, so, excuse me, if we decline, it's just lost revenue for those uses.
I believe so. And that's a question maybe I should ask the healthcare authority. If a county declines those dollars, I don't know if they go back to the state or if they go back to Greater Columbia and they disperse them out through other participating counties. I don't know what happens to those dollars if a county chooses not to participate.
Now, it sounds like you're waiting for some direction from the state at this time, Kyle. Could we readdress this?
Yeah, and I certainly think that we can. I think in reading the RCW, I believe that there should have been a panel guiding these funds all along. And so I think regardless of what happens with the new funding, I still believe that we need to look at forming a panel. I don't think the panel, I think the plan that is submitted to the healthcare authority, I think is submitted once a year. So I don't think it's with regard to the participants of the panel, I don't think it's a heavy lift in terms of time commitment. There might be several hours, one time a year in when it comes time to renew the plan. But I do have some concerns that there's a statutory requirement that this panel develop this plan and that the Board of County Commissioners sign off on the plan that gets turned into the healthcare authority. It's my understanding that Merit has turned in a plan on how the funds are being spent, but it's never been signed off by the board. And it specifically states that's a requirement.
Kyle, Commissioner Peck again. That was why I asked the question about what happens to the money if we don't do this, because so far I haven't heard any description of what administrative support would be provided to this panel in the production of this plan, and whether or not the cost of that administrative support feeds into this. I think if we're going to accept the funds, then clearly we have to do the panel. But I would like to have a better understanding of what the obligations and costs of the panel are, including, like I say, the administrative support, and who oversees or guides that effort. Is it Greater Columbia? Is it the county administrator? Is it your office? Who provides that?
Okay, I can certainly looking for my pen here. I can certainly.
And I can support creating the panel now if the feeling of the board is that we want to accept these funds. The question of who provides administrative support can be a follow-on question. But that just occurs to me that's it's one of those things, you create a panel, but nobody asks up front who's going to be responsible for it and provide administrative support and costs.
Okay.
Kyle, this is Commissioner Didier. Could you give me the full amount of the new monies at 6,000 and what? $6,591 a month. Okay, and can you also and maybe you don't know this, but how is Walla Walla County doing dispersing the funds through the commission?
I don't know. I can certainly reach out
Yes.
to the county and find out how they're, if there are problems. I would suspect there's, if the county chose to administer the funds, I know there's a 10% admin fee. It's a little bit murkier with the dollars going to GCBH, but then the county is being asked to follow up with these additional dollars. I still have some questions about that.
Yes, because what I'm most interested in is, did they create a panel in Walla Walla when they're administering the funds? Because honestly, this is what needs to be done either way for accountability and transparency.
I will reach out to Walla Walla, and I can certainly follow up with the board at a later date after I get some of these questions answered, if that's what you would like.
Yes, please.
Okay.
I think that is a path forward, Kyle, if you could do some of that for us, and so we're all a little better informed.
You bet. I will. I'll start researching this, and I can come back before the board here at a later date when I get some of these questions answered.
All right. Any further questions for Kyle this morning?
Mr. Chairman, Commissioner Peck, just want to make sure we're all clear here. Are we going to have Kyle go ahead with establishing the panel or not? I agree with Commissioner Didier that if we're going to accept these funds, we should have a panel. That's the right way to do it. So are we giving him instruction to go ahead and form the panel and then bring us back the additional surrounding details? Is that correct?
Will you take that on, Kyle?
Yes. Again, ultimately, I feel like if the county chooses to receive the funding, we have to have a panel. So I certainly don't have a problem coordinating that.
Great. I think I guess that was my impression anyway. So sounds like Commissioner Peck, Commissioner Didier, and on board.
Yes.
Yes, Chairman, I'm on board. Kyle, also, there's got to be some bylaws here of how that panel is created. Could you also inform us of that?
Yeah, it's in reading the RCW, it doesn't necessarily state how it's formed. It just identifies the required participants. Again, I think going back to a question Commissioner Peck had, I don't know that if we schedule a panel meeting and we have 4 of the required 7 participants, is that enough to move forward? I don't know. I can certainly clarify that with the healthcare authority. My belief is that it would be that you have to be able to do business but with regard to the RCW, it just refers to a plan. It doesn't identify that this panel is supposed to create or help guide. It doesn't give any template, doesn't give any indication as to what is required in that plan other than how the funding is going to be spent. And so I can reach out to the healthcare authority, find out if they have how involved that plan needs to be. Do they have a template? Is it just a Word document that we create? I don't really know any of that. I've never seen one of these plans, but I can also get some background information on that.
Well, Kyle, if you would, this is Commissioner Peck, would you just confirm that the panel, their sole purpose is to provide recommendations to the legislative body, in this case, the Board of Commissioners, and it's the Board of Commissioners that make the decisions on the distribution. Is that correct?
Yes, that's correct.
Okay, thank you.
Kyle, do you have that RCW close to you?
I do. It is RCW 71.24.580.
All right.
And the identification of forming the panel is section 6.
All right. All right. Anything further for Kyle?
No, thank you, Kyle.
Thank you,
You bet.
Kyle.
You bet. I'll get back with you. I'll get your questions answered.
All right, thank you.
All right.
All right, thanks, Kyle. With that, anything on the phone, Keith, at this time yet?
Not at this time.
All right, we will move on to office business in that respect, approval of payroll and warrant registers.
So, Mr. Chairman, I'm aware of one fiscal item this morning requiring the board's attention. This is fund expenditures. I move for approval of fund expenditures in a total amount of $705,716.24. Copy I have has been signed by two representatives of the auditor's office. There is a line for the county administrator. I'm assuming that he has subsequently signed off since this copy was printed.
Yeah, affirmative, he has signed off.
Okay, well, that's my motion for approval.
Okay,
I second.
all in favor?
Aye.
Aye.
Aye. That was one and only, Commissioner?
That's correct.
All right. That will bring us to the consent agenda, which is our items 1 through 4.
Mr. Chairman, consent agenda, as you pointed out, is 4 items. Move for approval as presented. I don't have a desire to pull any of these for separate consideration, but do have a couple of questions on item 3 when it's time for discussion.
Mr. Chairman, I second with discussion on item 4.
All right. We have a motion and a second, open for discussions. Just on the medical services item number 3, I just want to confirm that the PA's office has had the opportunity and has reviewed this item for legal sufficiency.
If I may interject, Commissioner, yes, I believe Frank Jenny from the PA's office has reviewed this. That was my understanding as of this morning.
Okay, it had a couple of components that were, I don't know if they're problematic, they were just a little atypical, so I just want to make sure it'd been through the full process. Mr. Chairman, that's the only questions I had.
Okay.
Mr. Chairman, I stand corrected. My questions were also on item 3. And my question is, what is the prediction of these RFPs? Now, I understand that Lady Lords is removing themselves from this. Do we anticipate this going up? Because we're already talking about $95,275 a month, plus $125 for after hours for a nurse, $220 for after hours of a medical provider, and we know a lot of the rest are made in the middle of the night. So what are we looking at here for an expense?
If I may respond to that briefly. Yes, jail medical has always been a very difficult process to manage, to be able to have the right personnel with the correct medical qualifications in the facility at the required time when those that are being held in the facility need medical attention. Commander Saltemeyer has done a great job of trying to minimize the cost, looking for grants to assist with that cost. And it's each year a difficult discussion to have about the rising cost of healthcare that we are required under state law to provide inmates in the facility. And recognizing that those inmates that are not properly treated medically are at risk to themselves, risks to other inmates, and risks to our staff from a safety standpoint. So it is generally considered critical and essential that we have appropriate medical professionals in-house in the facility to take care of those issues when they arise. It's also a situation where it's difficult for medical providers to do it at a cost that is sufficiently profitable to them They're not in the business of just providing free services, and it's difficult in today's medical business models for medical providers to make it pencil out where it's effective for them to pursue these contracts. So it's always a difficult process to find somebody who's available and willing to do it, has the proper medical training and staffing to do it, and then be able to keep those staff available, and at the same time keep our costs as a county to a minimum. But in general, we anticipate that a response to a RFP will allow those providers who do have an interest and do think they can make it work, give them an opportunity to respond to provide these services in our facility.
My other question is, the deadline is October 1st, or is it September 1st?
The current contract expires October 31st. So we would like to have a new contract in place before then.
Yeah. And the grant funding expires September 29th. Are those grants going to be available again?
I don't know if the new grant or the renewal of that grant has been awarded yet. I would have to check with Commander Soltemeyer to see if that has, that those are generally annually awarded, but I'm not sure if the new ones have been given out yet.
Okay.
Mr. Chairman, Commissioner Peck, just one added comment on item 3. I share the concerns that Commissioner Didier is touching on. I think they're the right things to be asking. But I want to point out what those of us who've been doing this for a little bit longer have found, which is that medical care for people who are in custody in our facility is an absolute requirement. It is fraught with risk, and the potential for litigation and surrounding costs are all very high. It is simply put a very high risk proposition or process or operation, and it is all necessitated by state law. We frankly don't have an option. So I share the concerns that I think Commissioner Didier is implying here, that this is very expensive and risky. I think that's all true. It's also all mandated by law. We frankly don't have an option. So I'm hopeful that we'll get a provider that we can afford, but we'll see how the process goes. But this is definitely a high concern area in my book.
Very definitely has been a high concern area since when I first got in this position, it was, very fractured at the best. We had a doctor that was supposed to be handling all this for like $150K a year, and it put us in a terrible liability, and that has taken our group now a long time to get through. So I think all their questions are pertinent, but it unfortunately matters not. We need to do it. So if there's no further questions, we have a motion and a second. All in favor?
Aye.
Aye.
Thank you. Anything on the phone yet, Keith?
No, not yet.
Okay. Well, it's your turn then, please, for
Okay.
office business.
Yeah, I have a few items I'd like to discuss. First, just kind of in the way of update regarding some COVID-19 information, CARES Act progress. We're making significant progress with TRIDEC and the grant program. A number of applications have received, and I don't have an exact count, but that deadline will be approaching, I believe, next week for applications to come in. I did participate in a number of phone calls late last week and this week with differing people around the Tri-Cities area. It included city managers and some mayors and city council members and different folks that are working to try to keep a community message together that evolved into some discussions with the folks at the State Department of Health, Dr. Kathy Lofi, who's the state's health officer, and Secretary John Weisman, who's the Secretary of Health in the governor's cabinet. There's clearly a recognition that Benton and Franklin County have had some unique circumstances. However, we're very similarly situated to Yakima County and a significant outbreak or increase in cases in Okanogan County. And so those 4 areas, Benton, Franklin, Okanogan, and Yakima County, have kind of been grouped together on the radar of the State Department of Health. What can be done to open up the economies more, at the same time work to decrease the numbers of COVID transmissions. We've seen in the last couple of weeks a reduction in Benton and Franklin counties. That's the good news, but our numbers are still significantly higher than many parts of the state. The governor's office and the State Department of Health are very focused right now on measures that would allow public schools to open again with kids going back to the classroom. And that's been kind of their first priority and focus. And as a result of, partly as a result of that effort, they have essentially put on hold any further advancement of awarding phases to counties. Some of the counties that went from phase 2 to phase 3, perhaps a little faster than they should have, saw an increase in cases. So the governor's office decided to essentially put a hold on the current phases until those case numbers subsided. That leaves Franklin County, at least for the time being, in our modified phase 1.5, with the anticipation that we could be in that phase for some time. So in order to recognize the efforts that we have made as a county and continue to make, we are working with the State Department of Health and those folks there to perhaps adopt further provisions that we would typically find perhaps in phase 2 without officially being awarded a phase 2 status. And I realize that's a bit of a distinction of terms, but they are working this week to assess that request, and we hope to hear something in the next day or two about whether that's possible. And what that might look like is additional opening of certain businesses, perhaps eventually leading to the opening of indoor dining and restaurants and some other changes to our professional services. So I don't want to speak prematurely, but we are hopeful that the state will allow us a little more latitude in our commercial activities in the county. I want to also point out to you that the CARES Act funding that we received, because it was not included in our original budget, state budgeting laws do require us to budget for that and pass an appropriation for that budgeted amount. So we have posted a notice for a public hearing. And the purpose of that hearing will not be to discuss the details of how we allocate CARES Act funding. It's just simply an opportunity to add that to the budget so that the state audit requirements are fulfilled and state finance and budgeting laws are fulfilled. So we've scheduled that to, as of right now, for our regular board meeting on September 1st. The second piece of that is, because of the way that the CARES Act has been set up, it's done on a reimbursement basis, which means the cash has to be spent first and then reimbursed to the grantees. And we are working with the auditor's office and the treasurer's office to consider a loan from one fund to the general fund to be able to have enough cash to pay these bills up front before we are reimbursed by the Department of Commerce. The process by which we get reimbursed from the Department of Commerce is not a lengthy one and should be fairly seamless, but it puts the county in a position of having to have some cash up front to be able to offer these grants to the community. Then the last piece of that, I have been in some discussions with the treasurer's office and the auditor's office about the possibility of refunding our jail bonds that were issued in 2012. Because interest rates are so low right now, it might make sense for the board to consider moving forward with a refinancing of those bonds. We're estimating, and it is just an estimate based on current rates, that we could save over $100,000 a year if we were to refinance those. So I'm working with Jim Nelson, who's been our bond advisor, to put numbers together and work toward a proposal that the board could consider in saving us a significant amount of interest costs over the life of those bonds that are still outstanding for a few years. So I wanted to bring you up to date on those. Certainly maybe I ought to pause there for questions about those items before I move on to a couple of others.
Questions, gentlemen?
No questions. I understood that.
Yes, Keith, you talked about, the first thing you talked about was, could you refresh my memory on the first thing? I've got a lot of things here on my mind.
Yeah, I talked a little bit about the COVID numbers in our community and the effort of the state to try to treat similarly situated counties together. Perhaps I didn't make this real clear, but as you can imagine, with 39 counties, the state is getting all kinds of phone calls and questions from each one of those 39 counties. They're in different phases from modified 1.5 all the way through phase 3. I don't believe there's any phase 4 counties. They have a strong desire to not go back. So if, for example, a county has been awarded a phase 3 status, they don't want to move them back to phase 2. But that is a consideration on the table if their case counts don't change. Then the same thing applies to us. We're in a modified phase 1.5. They're looking to try to add additional, lack of a better word, openings or activities that would normally be recognized under phase 2, but the governor's not yet ready to award new phases to any of the counties.
Okay,
So
my question on that was this. Do we have an account of the testing that's going on statewide, county by county? How many tests are being administered in every county?
the State Department of Health has that information. I can't verify the accuracy of it, but that material would be available.
Well, that's a very important aspect of this, to the fact that we all know that the governor lost his congressional seat here, and is the Tri-City area being punished because of that? I really want to know if we're being tested more heavily here in the Tri-Cities than they are in other parts of the state, in particular King, Pierce, and Snohomish.
Yeah, I certainly cannot respond at all to the political decisions that may be made in Olympia. I will say that we have had 2 testing sites operational in the Tri-Cities area that have been operated by the National Guard. One over at the Hapo Center, as you know, here in Pasco, and one over at the Toyota Center, Toyota Center in Kennewick. The governor has reprioritized the National Guard, and so they are shutting down the center, the testing site at the Toyota Center, and transferring some of those personnel over to the Hapo Center, where they will increase the capacity to basically a double line. So they are changing some of the availability of testing, whether that's politically motivated or of necessity based on where they're seeing the need for testing in other parts of the state. I couldn't respond to, but I understand the concern.
Yes, because I have received, as I'm sure the other commissioners have, 3 letters from photographers that are not being able to social distance and create revenue for their business. And they are hurting terribly, as are other businesses, because they are not allowed to take pictures and charge clients for that when it can be easily social distance with masks. And again, this is government picking winners and losers, and this is completely wrong.
Yeah, that specific profession of photography has been discussed with Dr. Lofi and the state. That was a matter that was discussed yesterday. And we are hopeful that they would be included in some of this new guidance that would allow those businesses to operate. But it would be premature at this juncture to guess what the state's going to ultimately decide.
Okay.
So Keith, Commissioner Peck, just following up on that, I spoke with the governor's staff when we got those emails from the photographers and the health district, and I don't know if that's what spurred the conversation with Dr. Lofi or not, but there's a number of us, Commissioner Didier included, who have been working to bring attention to that example, because it is one where I think we all agree it can be done safely. On the second point with respect to testing, there's a lot of debate about what testing really does, whether it identifies additional cases that otherwise would not be identified, or whether it simply identifies them on a different timeline, meaning if you don't get tested and you have the virus, you still get sick and it still gets identified eventually. It's just through a different mechanism, right? So it's interesting to me, and I'm not making conclusions here. I'm offering just an observation. We've had pretty robust testing in the Tri-Cities, and we've had some pretty high case counts. I'm not aware of any sort of structured or emphasis testing in Okanagan, yet they have some of the higher numbers in the state. And so I'm not sure. I used to think that more testing meant more virus, but I think it just identifies it on a different timeline, because it's hard for me to explain why Okanagan would have the high numbers they have in the absence of testing. Just an observation, not trying to drive a point.
And on the testing part of it also, this is Commissioner Didier again, I've had 3 testimony from people that were in line to get tested, filled out the paperwork, got tired of waiting and left, and a few days later got a notice in the mail that they tested positive. I want answers to how they tested positive when they didn't even take the test.
Well, that's particularly interesting, and Keith, maybe Commissioner Didier can share that information with you. You can run it by the health district, because it's a great question. I'd love to know the answer too.
Absolutely.
Got a Board of Health meeting tomorrow, so that can be brought up at that time.
Yes, and they're for everyone to see. They're on Facebook, and they're pretty upset with the fact that they've been labeled positive when they didn't even take the test.
Yeah. Okay. Keith?
Okay. The other issue I wanted to discuss, if we could, we received a notice from the county auditor's office regarding commissioner vehicle allowances and prosecuting attorney vehicle allowances. You will recall that we made a change to the county travel policy back in December, and that subsequently led to a change or a recognition that we had not properly included commissioner vehicle allowances and the prosecutor's vehicle allowance in the travel policy. So in May of this year, we essentially rescinded a earlier resolution from 2012 that had not been properly applied to travel claims for commissioners, with the language that would then be added to the travel policy. That resolution came before the board to adjust the travel policy in July, but the board decided they didn't want that language specifically in the travel policy, and so they denied or rejected that resolution. So under the auditor's office's interpretation, that left a question or a concern about the legality of continuing to approve those monthly vehicle allowances. My personal view is that if the action that was taken in May was insufficient, then the action that was, or the resolution that was passed back in 2012 would have still been active and would have allowed the continued payment of those vehicle allowances. The auditor has taken a different position. I think you've seen that email. I've asked the prosecuting attorney's office to advise us on it. And so far, I think we're in agreement that it was the clear and express intent of the board to continue to make those vehicle allowance payments. And perhaps it just needs a more eloquent adjustment to the overall county travel policy to recognize that the vehicle benefits to the commissioners and to the prosecuting attorney are not county policy, or not county travel policies, but they're a special policy that should exist independently of the county's travel policy. So I want to make sure that you're aware of that discussion, and I would invite anyone from the auditor's office who may be on the line that would like to speak to that, and certainly invite Jen Johnson to speak to it as well.
Any comments from anybody?
Is
This is
the,
Jen Johnson.
go ahead, Jen.
I think it's important that we put this in a policy. When we did it back in 2012, we did it in a resolution. It could have even existed before that, I don't know. But it was done in a resolution, and resolutions get buried. So in this particular case, we had new employees that had no idea that this resolution existed. And then older employees that did know it existed. So we had a difference in how people were doing their travel. So whether it goes in the travel policy itself or whether it goes in its own policy, I do think it's important to have it included in a policy. So when we have new employees that come on board, they go to one place, read all the policies, and they're educated on how we run things in Franklin County. Because otherwise, in a resolution, you get a new employee, they're not going to go back and read, hundreds of thousands of resolutions. So I do think it needs to be upfront somewhere in some policy, regardless of which policy you pick it for.
Mr. Chairman, I think that you and I both agreed at the last meeting that this should not be convoluted in the travel policy, because this is a reimbursement due to the fact that you got a county vehicle. The other three participants were then compensated with a 50-mile radius for any travels with their own vehicle. And the only reason why this has come to be in the light is because there was one participant that was putting in for that 50-mile reimbursement when he was already paid for that 50-mile radius. And that's really the only reason that this is, when I asked for that review of the travel policy, it wasn't resolved then. It was only resolved after a private citizen got involved. And those funds were paid back when we were told there was nothing wrong. So it has really put a bad light on our travel policy that I think needs full attention and review and updated.
Well, and again, this is why we need to take it out of the resolution status and put it in a policy. Because the person processing the travel policy didn't know that that was a 50-mile radius thing was a rule. The auditors double checking this also did not know it was a rule, so they didn't catch it either. So that's what I'm saying. It needs to be in a policy, whether it be in the travel policy or whether it be in a standalone policy. It needs to be in a policy so everybody is aware of it.
Now, Jen,
it took me a long time to find it when I was looking for it.
Jen, are you saying the person that was that paid back that 50-mile radius was unaware of it?
No, the person processing his paperwork.
No, they were aware of it too, because they sent an email, the fact that this
No.
was.
No, the person processing his paperwork nowadays did not know about it. I had to point out where it was. That's the problem we had. And the auditor's office now, with the new people, did not know about it. The person caught it back in 2014. That person no longer works here.
It works for the Public Works Department now.
So this is the problem. When we get new employees, they need to know what all the rules are. We can't bury rules in resolutions from 2012.
Okay, but
We need to put it in a policy.
is it the employee's responsibility or the person that wrote the policy's responsibility? The people that are getting reimbursed, isn't it their responsibility, Jan, myself included?
You know what? You may or may not catch it. I have somebody that my travel in my office. I rely on her to know all the rules. So if you're relying on the person that's doing your travel to know the rules and they don't know the rules, that puts them in a bad situation and it's unfair. So it needs to be in a policy. I'm not going to go in the county travel policy, but it needs to be in a policy where, new employee.
Hey, Commissioner, let me interrupt you if I may. Sounds like Auditor Matt Beaton is on the phone and wants to speak to this.
Okay.
Matt, is that you?
It is.
Okay, you're on the public line, so please go ahead.
Oh, I appreciate that. I think there was, I guess, I just wanted to comment. These call-in meetings make it difficult, but some of the summary by the PA's office representative, I think, is missing one of the most important parts of any policy. When you try to put it back as though the auditor is responsible for catching everything, we miss a really important thing as an entity, that the signer for the reimbursement is responsible. And we process these things, but we take everybody on their honor when they sign that stuff. We are not in here trying to catch people that are either misunderstand the policy or whatever. The reason I included all of this information in that letter was that it demonstrates, we're the county that had the largest and longest fraud in state history. And many of us were here when when that was prosecuted. And it all came down to, the responsibility of the individual that signs on the bottom line. And so that's all this was about. And the reason this got rejected was this was right now we're stuck in an administrative limbo. And as the auditor and my staff pointed out, we were working with it for 2 or 3 payments. And then, unfortunately, you guys, the board is still trying to work through this. And so with that in mind, we shouldn't run these numbers up until it's settled. And that's the only thing that gives, and that's the auditor's role, is to assure that a resolution authorizes payments. We're kind of stuck in limbo. I know the board wants to work on it, but when my staff put that, put the new travel policy together, that particular thing was rejected. And so now we really lost in the meantime the ability to say, well, we understand. I understand your argument, Keith. You're saying, well, their intent is to eventually fix it. And I get that, but it's not now. And now I no longer can look at the auditor or anybody or even the public and say, this stuff is authorized. And as far as the difference between the resolution and the actual travel policy, that's up to the person. The commissioners, there's only 4 people. And so to act like that, they know, they wrote it. So they know the resolution. And ultimately this slipped through for whatever reason. And it was caught and handled. And right now it's where it's at. But whether or not you push those 2 things together administratively, that's a decision the board gets to make. But the resolution and the separate travel policy worked for almost a decade. And so the question is, ultimately, whoever's applying for this is the one that's responsible for understanding, the difference. And I think the analysis showed that. that, you know, that the other participants, seemed to understand it or it got done. And there was some errors made here, and that's all, whatever it is. We just need the board or you, we just need to, give the authority back through a resolution, to authorize those payments to go out. So even if you put it in the travel policy, I think you'd still have to have a resolution to authorize it. Those particular expenses, just like we have resolutions that authorize budgetary travel and that kind of stuff. So I guess we can figure that out as an entity.
With that said, commissioners, I guess it would be my recommendation to bring back a resolution that speaks to what the auditor just indicated and grants the authority to reimburse for those prior months' travel or vehicle-related expenditures, so that those officials will not be harmed in the process, because I think that's clearly been the intent of the board from the beginning. And the fact that it appears that there's disagreement over the interpretation of policy within those resolutions should be handled just in that way, administratively, with a new resolution that satisfies the language requirements of the prosecuting attorney's office, my office, and the auditor's office. So if it's your pleasure, I'll work to bring that language back.
All right, I think what should carry forward on that.
Commissioner Cook?
Yes.
Yeah, Commissioner Peck, just a quick comment, if I may. Keith, if you do bring back such a resolution, would you make sure that is properly vetted to make sure we don't find ourselves in a difficulty with respect to retroactive payments and reimbursements? We have enough issues with that already. Thank you.
Absolutely, will do.
I guess, and my comment is for Mr. Beaton, that you keep saying it's the signature's responsibility to be proper, and his employees aren't going to be looking at it. Well, that is totally wrong, because I have sent in travel vouchers and I have miscalculated the areas of meal reimbursements, as in Seattle or Olympia or whatever, and I got them thrown back at me in a heartbeat. So there is somebody looking at them besides my signature. So that's all I have to say.
Oh, and I appreciate that, Bob. And actually, that is, we do audit. So I want you to understand that absolutely, you know, we do audit the process. So there's no doubt that we check everything vis-a-vis the travel policy and that kind of thing. But what I'm trying to say is that ultimately, and that's why we try to help everybody get it right, you know, but ultimately we do come back to you to change it. We don't change it for you. And we're not in and I guess I would caution anybody who just is gonna not review the policy each time, or, you know, I mean, clearly we as elected officials are responsible for being reimbursed in everything we do. And then the auditor's office will take the policies that are there and apply them. But I mean, to suggest that after 5 or 7 years of this, that it was somehow someone else's fault, it just doesn't ring true to, you know, to how, you know, the standard of public representation. So I don't know what the suggestion is, that somehow this is someone else's fault. So that's the part where I'm taking umbrage with that.
You know, I did not say it was someone else's fault. I said multiple people missed it because it's not obvious. It's not out in a policy. We need to make it in a policy so people can find it and everybody knows the rules. That was my point.
Well, I would note that the conversation surrounding it, there was actually a disagreement with the actual person. My understanding, I don't want to get into the technical part of it. Here's what it is. The two policies Like I said, it's been around for 8 to 10 years. It was, everyone seemed to understand it. There was confusion by one participant. That has been worked out. However the board decides to solve this, that will give, this office the authority to go forward. None of this would have happened if we weren't in limbo with changing the policy that was unamendable. Then we attempted to amend it, and then that was, so, from a procedural standpoint, we'll do whatever the board's pleasure is on that. We just need to make sure they put that in writing for us to follow.
All right, so Keith, you have,
Yeah, I think I have what I need to put this together for you.
anything further on the phone?
I think that's all I have, and no other callers at the moment.
Okay. All right, so anything else for the good of the board?
Yes, Keith?
Yes, sir.
Yeah, okay, so why isn't all the department heads on this conversation? Why is Otter Beaton calling in on the call-in line?
I don't know why he's called in on the public line. We've made the inside the county number available to everyone, but he may be remote and in a place where it was more convenient. I have no idea.
Okay, and then the other question is, we've got these cameras on our computers and we've had complaints. When are we going to go to a live meeting where they can see the commissioners?
That's a decision, I suppose, of the board. If you want to be visible visually, that can be.
Well, we've had requests for this.
We have one person request, yes.
Yes. So I'm just curious, every meeting, Commissioner or Chairman Cook and myself are in the courthouse, and Commissioner Peck is somewhere out and about. So I just want to know, when are we going to do this virtual meeting where we are visible to the public? Because that is very important in Open Meetings Act.
That may require us to acquire additional technology or using a different format. I don't personally know the technical requirements to do multi-person YouTube presentation or multi-person on our AV capture system. I'm aware that there are other products like Zoom and GoToMeeting and those kinds of things that do allow multiple cameras on one screen, but I'll need to look into that. But I don't have
every meeting that I'm attending outside of this is virtual and it's Zoom. And before I get off the line here, I had that question in the minutes about the PA saying that he didn't agree with the proclamation and the sheriff won't enforce it. And if the PA doesn't agree with it and will not enforce it and the sheriff won't enforce it, I would say we need to get back to the chamber, social distance, and have our meetings in the chamber, because who's going to enforce it? The health board? They said they're not enforcing this. And honestly, if the courts are in session with members in the courtroom, this is no different from that. And under the Open Meetings Act, I think we need to be in the chamber, visual to the public that we're representing.
Yeah, I don't disagree with you in principle. I do think it's helpful to the public to actually have visual contact with the commissioners. I would say that's not a requirement, and the fact that it's not being enforced by the sheriff or the prosecutor locally, I think is a bit problematic, in that if it's still the requirement or the law, I cannot in good faith suggest or recommend to the board that you violate the law just because no one's enforcing it. It'd be similar to places where traffic laws are not well regulated or enforced, does not authorize us to speed or run through a stop sign. I would be troubled a little bit by us trying to do something that is not appropriate. I am empathetic, of course, to the idea of having cameras, at least where they can see you in person. Archiving those documents or those recordings may be a bit of a challenge, but there's probably a solution to finding an opportunity to do that.
So then are you suggesting that our court system is breaking the law?
Oh, no, absolutely not. They have,
I could speak to that,
please.
Keith. They are under a different order than the Open Public Meetings Act order. They are under an order by the Washington Supreme Court that allows them to hold meetings. That being said, or court hearings, sorry. That being said, very few are actually showing up in person. Most of them are utilizing our technology to appear by telephone.
Okay, anything else for the good of the board? Either commissioner? Nothing, Keith?
No.
Amanda?
Think we're good up here. Thank you.
All right. With that, we will stand adjourned. Thank you. As of just an update, I was informed yesterday we will only have one consent agenda that is not imperative next week. So I think we have until the end of business today for anything further. So you may watch for an adjournment next Tuesday. So just keep that in mind at this time. So other than that, we are adjourned. Thank you.